for this program, Dispelling Myths, Enforcement of Latin American Arbitration Awards in the United States and U.S. Arbitration Awards in Latin America. My name is Lee Haber-Cook, and in addition to being the co-chair of New York Arbitration Week Organizing Committee, I am also the chair of the Arbitration Committee of the New York City Bar, which is sponsoring this program, along with the Latin American Affairs Committee and the International Commerce Committee. There will be CLE credit for this program, and you should have received an email with the required forms, but if you did not, you can also find them on the New York Arbitration Week website under our event page. And Professor Garro will provide the required code later on in the program. We have a stellar panel today from all over the Americas, and I'll turn it over to Professor Garro so that we can hear from them.
Thank you very much, Leah, and good morning, good afternoon, and good evening to everybody. We have, as Leah just pointed out, a wonderful panel, all of whom are going to be addressing the issues of recognition and enforcement of arbitral awards in 5 different jurisdictions in the Americas. We'll start with the United States for people to feel acquainted with their legal systems of the US and the Federal Arbitration Act, and then we'll move south and we'll find different jurisdictions. I will introduce each member of the panel as quickly as I can. There are all of them with tremendous accomplishments, so I will highlight some of those accomplishments, and each of the speakers will have about 10 minutes to present their point that they think most significant in this area. And then eventually we will shoot, and I hope we'll have enough time for questions, and you can raise them through the question and answer mechanism there. There is also reference to the forms that you will find in the webpage of the New York Arbitration Week for those who are applying for CLA credit. And I will, of course, before the end of the program, I was asked to provide you with a code that you would take note with it. So we will start then first one with the United States, addressing the issues of recognition and enforcement of foreign arbitral awards. And I will introduce to the audience Jennifer Perfley, who is a partner and international litigation arbitration group at Skadden Arps, a firm who has been contributing very much to the organization of this panel. Much of her practice of Jennifer is disputes arising in Latin America, and among her many accomplishments, she serves as a co-chair of the International Bar Association's Insolvency and Arbitration Group, which in 2021 published a tool on insolvency and arbitration to provide guidance in situations where a party to domestic or international arbitration is also subject to insolvency proceedings. She also serves as a chair of the Global Advisory Board Relations for the New York International Arbitration Center. Of course, Jennifer has many more accomplishments, but the floor is yours, Jennifer, to start with our discussion. Thank you.
Thank you so much, Professor Garro. And thank you to the organizers for inviting me, and especially to the New York City Bar Association Committee who's organizing this event. I've been talking and writing about enforcement of arbitration awards in the United States for a number of years now. And I think it's safe to say that the law in this area has been fairly stable. It hasn't changed drastically in many years. But because of the way the system works in the United States, that we have a common law system and many different courts may be able to address questions of enforcement across the country, federal courts, state courts, et cetera, there's room for mischief, right? There's room for decisions that maybe go a little bit outside of what parties would have expected. And sometimes a federal circuit court or the Supreme Court reins it back in, and sometimes they decide not to rein it back in. And so one could forgive our Latin American colleagues or other folks outside of the US for being maybe a bit confused or perplexed about the exact state of the enforcement proceedings in the United States. So what I thought I would do today, I don't know if Alex or Jesse can throw up my slides, but I wanted to just cover really 2 areas where I think that there are some questions about what the state of the law is. So if we can go to the second slide, Alex. So I'm going to talk in my opening presentation about items 1 and 2, setting aside an award for lack of arbitrator jurisdiction, and setting aside award for what sometimes called legal error. I won't address in my opening presentation 3 and 4, awards that have been set aside at another seat and need to be enforced in the US. or emergency arbitrator awards, but I'm happy to come back to those in the questions later or if time permits. So tackling the first issue, going to the next slide, will the US courts set aside an award for lack of arbitral jurisdiction? I think this is an area where the US has often been heavily criticized because although we honor the doctrine of competence, we place limits on that doctrine in the United States. And it is still very much the law in the US, this is reinforced over and over again by courts, that it is really a question for a US court rather than for an arbitrator, whether an arbitrator had jurisdiction over the matter, the parties, the scope of the dispute. I think some people are surprised to be reminded of that. Will a US court really revisit the decision on arbitral jurisdiction in an enforcement proceeding? And the answer to that is yes, they may in fact do so, but let me tell you about really how that works. Because in the last decade or so, there's been an exception that I would argue is so great of an exception that it's basically in effect swallowing up the rule and allowing arbitrators to make their own jurisdictional decisions. And that is that, the law has always said that if there's clear and unmistakable evidence, that's the language that's used, that the parties intended to refer jurisdictional questions to the arbitrators, well, in that instance, the court won't get involved. They will not review that question de novo in the enforcement proceedings. They'll defer to the arbitrator's jurisdiction. And the law has expanded that clear and unmistakable evidence concept to include any circumstances where parties have incorporated in their clause the arbitration rules of an institution that allow the arbitrators to determine their own jurisdiction. So today, almost all modern day arbitration rules, ICDR, ICC, AAA, et cetera, have a provision in them saying that the parties allow the arbitrators to make decisions on jurisdiction. Incorporating those rules alone has been held repeatedly by courts to be sufficient to allow the arbitrators to find that clear and unmistakable evidence that the arbitrators, rather than the court, should be deciding the jurisdictional question. Now, if you haven't incorporated arbitration rules that have that provision in your agreement, if it's an ad hoc arbitration or some other quirk, you may still be in a situation where the US courts will review that decision. Going to the next slide, let me tell you a few other quirks in the law. This issue of does the incorporation of rules end the story, right? Does that mean the arbitrators can decide? The Supreme Court has actually never passed judgment on it in the United States. We all very anxiously awaited court doing so in the Henry Schein case, which was recently granted certiorari by the Supreme Court, but they declined, they never ruled on that issue. Instead, they took up certiorari over a different but related issue. That related issue was essentially as follows. The Fifth Circuit Court of Appeals, which is a court of appeals that sits in over the courts of Texas and some other jurisdictions in that area of the United States, had held that although the general rule was, yes, incorporation of rules like the American Arbitration Association rules means you defer to the arbitrators, there can be exceptions to that where the parties specifically carved out certain types of disputes. And so I have up on the screen the clause that was at issue in the Henry Schein case, but it basically said any dispute arising under or related to this agreement shall be resolved by the rules of the AAA, except for actions seeking injunctive relief and disputes related to trademarks, trade secrets. And the Fifth Circuit held that that exception meant that interim relief, injunctive relief applications needed to be decided by the courts, and the arbitrators couldn't themselves decide whether or not to look at a question of injunctive relief. The Supreme Court granted cert to decide whether or not that was the right path that the Fifth Circuit had taken. And again, we all waited anxiously, hoping that the Supreme Court would look at this issue carefully. And instead, the Supreme Court in January of this past year dismissed the cert petition as having been improvidently granted. In other words, it said, we don't really want to decide that question at all, never mind, which is a somewhat rare thing for the Supreme Court to do. And it effectively leaves the decision of the Fifth Circuit intact. So where are we in the law in this area? Very big exception, incorporation of arbitral rules means the arbitrators get to decide jurisdiction. But if you have indicated something in your clause that suggests an exception to that, that may be upheld by US courts. It actually is an important case in that we often see contracts that have a provision for interim relief going to courts in one place and an arbitration clause in another place. And sometimes the corporate lawyers are not marrying those two to make clear that they didn't mean to take away jurisdiction from the arbitrators when it comes to a question that requires injunctive relief. Now that this decision has been handed down, we are very, very careful, at least at Skadden, when we look at our drafting of the clauses to make sure that we are being very explicit that the interim relief applications being able to go to a court is not meant to exclude arbitral jurisdiction. So I'm telling you also that you can apply that in your practice as well. It's important to catch it at the clause stage rather than after the fact. Moving to one other issue related to lack of jurisdiction, going to the next slide. I wanted to just spend a moment on what happens when the challenge to jurisdiction has to do with the fact that somebody was not a signatory to the arbitration agreement in the first place. Courts have been weighing in on this in recent years as well. And the case law that's emerged is actually quite interesting. The courts have said, look, if you are yourself the signatory to the arbitration agreement, you can't come to a court and say, I don't really want the arbitrators to decide if that non-signatory can arbitrate with me. You have already agreed to the arbitration clause, to the provisions that delegate jurisdictional decisions to the arbitrators in the rules. And therefore, you cannot say, I didn't mean when a non-signatory was involved. So the courts won't review that. The non-signatory, on the other hand, could come to a court and say, I would like you to review whether I actually agreed to arbitrate. And the reasoning is really because there's no clear and unmistakable evidence that the non-signatory intended to arbitrate if it argues it didn't enter the arbitration agreement in the first place. Maybe there might be an argument that it did, in fact, mean to be bound by the arbitration agreement, but until a court finds that, they don't have the clear and unmistakable evidence on the face of the arbitration agreement itself. So in that way, this is another exception to the rule, which says that courts will examine arbitral jurisdiction where a non-signatory argues that it was not bound to arbitrate. The final thing to say in this area is that in a recent Supreme Court case that was given a lot of attention, the GE Energy case, the Supreme Court upheld the standard that is long applied in the US, which is that a non-signatory may be bound to arbitrate under a number of different domestic equitable estoppel principles. It's an alter ego. It assumed the agreement by its conduct. It was an agent or it incorporated by reference the agreement into some other documents. All of these still stand. In that GE Energy decision, the court declined to find that the fact that the New York Convention refers to a signed arbitration agreement would somehow override the application of these principles when it came to a non-signatory. So we were all very happy to see, I think, that correct Supreme Court decision. Moving to one other topic, the other area that gets a lot of criticism in US enforcement jurisprudence is whether or not the US courts will review arbitration awards for legal error. Many of you are probably familiar with and have heard this manifest disregard of the law standard, which has developed in the case law as a common law ground for vacating an arbitration award. You can't find that language in the Federal Arbitration Act, but nonetheless, courts have consistently referred to it as a possible ground for overturning an award. There was a US Supreme Court decision that didn't directly decide this issue, but touched on what grounds are available for vacator. And following that decision, there's really been a very significant split among the circuits in the United States about what the status of the manifest disregard doctrine is. Several circuits have held it doesn't apply when you have an international arbitration award because those shouldn't really be subject to these common law vacator grounds. That's a Seventh Circuit position. The Fifth, Eighth, and 11th circuits have held that it's no longer a valid basis to vacate an arbitration award at all. But other circuits do continue to apply the doctrine, and New York is one of them, and I'll talk about that in a moment because we are here at New York Arbitration Week. A few years back, I participated in a debate at the ICC's Miami conference, and it was a debate for the Young Arbitrators Forum about what's the best arbitral seat. And there were a bunch of us that argued in favor of our seat, and I argued in favor of New York. And it came down to me and my esteemed colleague from Hogan Lovells in Miami, and ultimately Miami was voted as the winner of the debate. really principally because the 11th Circuit, which is a court of appeal that sits over the courts in Florida, has held that manifest disregard of the law is no longer a basis, and I was not able to say the same about New York's standard. Now, I understand the outcome of the debate, but I will say that I think that the way that the New York courts are applying this standard is extremely limited, and I think that that's been proven over and over again, and maybe even sometimes can play a little bit of a gatekeeping role where an arbitrator has really gone off the rails. So let's look for a moment at the next slide at how the New York courts are applying this doctrine. The Second Circuit, the Court of Appeals that sits over the New York courts, has said, the New York federal courts has said that we do maintain the concept of manifest disregard, but it's not really meant to be some new ground that doesn't exist in the FAA, the Federal Arbitration Act. It's meant to be a shorthand for things that are already there. We obviously will vacate an award for arbitral misconduct. We obviously will vacate an award for excess of authority. It fits within one of those concepts. And to apply it, you really need to find at least two things to be the case. One, that the legal principle in question was clear and directly applicable to the arbitration. It's not just that there was any legal error. There's a specific legal principle that we know applied here. And then second, the most important part of the standard is that the arbitrator knew of its applicability, but intentionally disregarded it. So it's not that the arbitrator got it wrong or didn't fulfill its mandate to carry out the contractual interpretation or analysis correctly. It's that the arbitrator ignored the law. And that's really what the standard continues to be in the Second Circuit, in the New York courts. A situation in which the arbitrator says, I don't care that the statute says that. I don't care that the binding precedent out of the Supreme Court is XYZ. I'm going to decide based on my principle or principle that party Z argued to me. That doesn't offend my sensibility. I'm sort of okay with courts playing that gatekeeper function in the way that I think the Second Circuit is appropriately carrying it out. And to sort of prove that I think it is being carried out appropriately, we can look to a 2012 report by the same Bar Association Committee of the New York City Bar that's sponsoring this panel, which looked at all of the manifest disregard cases out of New York and found that no international arbitration award rendered in New York has ever been set aside in the Second Circuit on the ground of manifest disregard. I do believe that is still the position today, almost 10 years later, but it is comforting to know that the way that the doctrine is being applied is only in these very limited circumstances. So I'm going to end my main presentation there. There are many other interesting things to talk about in US enforcement law, but I think these are two areas where people need to be aware what the true state of the law is and think about how to use that to their advantage in enforcement in the United States. Thank you so much.
Thank you very much, Jennifer. And definitely all the issues that you touch upon, each one of them deserves much more discussion, but I hope that we can leave that for the question and answer theme. Let's move now to Argentina, and Maria Inés Corrá will be with us discussing issues on our international commercial arbitration and the recognition and enforcement of awards. Maria Inés Corrá is the co-head of the international arbitration, administrative law, and economic regulation areas at the law firm of Bombshill and Bombshill, and she has almost 20-year experience in the arbitral practice, representing lots of companies. She is the president of the Arbitration Commission of the ICC in Argentina, member of the board, and secretary of the Latin American Arbitration Association, and co-founder and leader of Women Way in Arbitration Latin America. She's also the member of the Arbitration Committee of the IBA, among other roles. She also is a professor of arbitration and mediation at the School of Law of the Torquato Di Tella University. Thank you very much, Maria Inés, for being with us, and the floor is yours now.
Thank you, Alejandro, and the organizer for inviting me to join this panel and my dear colleagues. First of all, Argentina, as you may know, Argentina ratified the New York Convention in 1989. As a treaty, the convention has hierarchy over domestic law. More recently, in 2018, as the Argentine Congress approved the International Commercial Arbitration Law, which adopted the Uncentral model with minor changes. Therefore, we can say that Argentina has now a model legislation governing recognition and enforcement of arbitral award. Before explaining or briefly explaining in these minutes the Argentine case law on the matter for the benefit of the audience. Let me also tell you that in Argentina, there is not one and only competent court to hear and decide on enforcement of foreign awards. Both federal and provincial courts, we call them provincial courts, that they are the state courts, may be competent to do so. And another issue, another thing to take into account is that case law is not binding, but for the parties involved in the matter. However, lower courts usually follow the Argentine Supreme Court case law in that matter, in this matter also, and when if applicable, of course. Turning to the case law, from the beginning of this century, Argentine case law has on this matter has evolved in general terms in a positive direction, I would say. Due to time constraints, I will make reference to, or I will try to make reference to three relevant decisions rendered by the Argentine Supreme Court in the last years. The first case is the Armada Holland versus Interfleet case of November 2011. The parties of that case had executed a charter party agreement to carry a cargo of fruit from Argentina to Russia, and that agreement made reference to a counter party insurance standard form containing an arbitral agreement which provided for a sole arbitrator with seat in London. Well, a dispute arose between the parties, and defendant alleged that it had that it had not accepted the appointment of a ship by the ship owner, either in a signed document or through an exchange of letters or similar documents. Therefore, the defendant denied the existence of an arbitral agreement in writing as required by Article 2 of the Convention. The lower courts upheld the defendant's argument, sustaining that under the New York Convention, the verification of the existence of a valid arbitration agreement is a specific task of the enforcement court. The Supreme Court, by majority, set aside that decision, holding that, first, according to the file, the sole arbitrator had found that the contract containing the arbitral agreement did exist. Therefore, having the arbitrator already ruled on that matter, on that issue, the enforcement court had no jurisdiction to review that finding. Therefore, the Supreme Court stated that the verification of the legal requirements provided for in the New York Convention to proceed with enforcement of award does not allow any review or modification of the decision on the merits made by the arbitrator. This of course is a relevant doctrine, but the Supreme Court held that no matter if those issues may be intrinsically related to the grounds for denial of recognition and enforcement of foreign award under the Convention. First case. Second case. The second case of the second matter is the so-called Deutsche Case rendered in September 2019. In this case, claimant sought recognition and enforcement of an award rendered by an arbitral award seated in New York, and of the confirming decision rendered by a district court of New York. The award had ordered the Argentine state and two insurance state entities to pay approximately $7 million plus $8 million of interest to claimants. And in that case, among other objections to the award, the defendants alleged that the award had failed to apply the debt consolidation regime applicable to credits against Argentine state entities, the provision of which were of public order nature. The first instance court denied exequatur. However, the Court of Appeals held that the omission to apply the public order debt consolidation regime by the arbitral tribunal did not prevent the enforcement court from granting partial enforcement of the award by modifying the decision in order to adapt it to the public order regime, something that domestic law allows to do. The claimant consented that decision, and the Supreme Court confirmed the Court of Appeals ruling, and concerning this main issue of whether the enforcement court had the power to modify the award to adapt it to a public order regime, the Supreme Court confirmed that power on two grounds. Article 3 of the Convention, which, as we know, prevents the imposition of substantially more onerous conditions on recognition and enforcement of foreign award than domestic award, and Article 7 of the Convention, which allows the parties seeking recognition and enforcement of foreign award to rely on a more favorable domestic law to obtain the enforcement, as happened in this case. Therefore, in this second case, the Supreme Court again confirmed the favorable approach to the enforcement of foreign awards following the spirit of the convention. The third case relates to a very, very recent Supreme Court ruling in Re Milantic versus the Ministry of Production and others, rendered in August 2021. In this case, claimants sought recognition and enforcement of an award rendered by a London-based arbitral tribunal against Astillero Rio Santiago, which is a shipyard company wholly owned by the province of Buenos Aires, the state of Buenos Aires. The parties had executed a ship construction contract which contained an arbitral agreement. Defendants, in this case, the province of Buenos Aires, and this company, the shipyard company, which is a state company, alleged that the arbitral agreement had been executed without a law approving that agreement and enabling Astillero Rio Santiago to submit to arbitration. Therefore, defendants, or according to the defendants, there had not been a valid arbitral agreement to vest jurisdiction to the arbitral tribunal. Here, this very brief note, the legal authorization for state entities to arbitrate is a generally accepted condition established by Argentine case law in Argentina on this matter. The first instance, which is the first instance on contentious administrative matters based in La Plata. La Plata is my city, and as long as I know, Professor Garro also rejected the defendant's objection and upheld the enforcement of the award. The decision became final because the defendant didn't challenge it, but for the ruling on cost. However, the Court of Appeals set aside ex officio the first instance ruling based on the absence of a valid arbitration agreement duly approved by law. That decision was confirmed by the province of Buenos Aires Supreme Court, and both decisions were highly criticized by scholars and by practitioners at that time. The case was submitted to the Federal Supreme Court, and the Supreme Court finally revoked the Milanchik decision, holding that the power to verify ex officio the grounds for denial of award recognition and enforcement set forth in Article 5.2 of the Convention cannot be exercised against other essential principles, such as the congruence principles, the res judicata principles, which also belong to the international order public and should be equally respected. Therefore, and this is, of course, we congrats all the same scholars and practitioners now congrats the Supreme Court due to this decision. These three cases and decisions by the Supreme Court shows that at least the most recent Argentine Supreme Court case law departs from any possible mything against the enforcement of foreign award in Latin America, at least in Argentina, since this case law respects the limited scope of the grounds for denial under the convention and preserve the spirit of the convention, which is to favor the enforcement of foreign award by the contracting state courts. There are still other issues open, mainly the enforcement of exit awards or awards resulting from investment arbitration, because all these case law mainly deal with commercial arbitration, commercial international arbitration, but we can say that at least now, and in view of the recent decisions by the Supreme Court in Argentina, we can have hope. At least we can have hope to a positive case law in this matter. Thank you, Alejandro and the panel.
Thank you very much, Marinés, for this quite optimistic view of the recent trends of the Supreme Court decisions that you just mentioned. Of course, these are decisions by the Supreme Court, and as you pointed out at the very beginning, both the setting aside and the recognition and enforcement is maybe ended up in state or federal courts of lower courts. And Jennifer already pointed out that there are some divergences between circuits in the United States about issues of manifest disregard, and she pointed out very clearly. So we are moving now to Brazil, where, unlike Argentina and the United States, there is one court that actually in charge of all these matters, and is a federal court and a high federal court, and that will be in charge of Marcela Levy, whom I have the pleasure of introducing today. She is a partner at Mannheimer, Perez and Lira Abogados since the late 2016, and holds a degree from the Catholic University of Rio de Janeiro, from PUC, and also an LLM from Columbia University. And Marcela is a member of both of the Brazilian Bar Association and also admitted to practice in the state of New York. She's also a member of the ICC Arbitration and Mediation Committee, as well as the Brazilian Arbitration Committee. Just ending up among her many accomplishments, that she has been widely recognized by international publications as a leading young practitioner in Brazil. So Marcela, we're all listening to you. Go ahead, please.
Thank you very much, Professor Gajo, and for the New York Bar Arbitration Association for the
Marcela,
invitation.
excuse me the interruption. I want to make sure that the slides can be shared with the rest of the audience. And
Yes, please.
If that possible, that would be great. Thank you so much.
From my perspective, yes, please. So I'll be speaking from the Brazilian perspective. Next slide, please. So here I have an overview of arbitration in Brazil. We have a 1996 Arbitration Act, which is widely based on the Uncentral model law. In 2001, there was a declaration of constitutionality of this act by our highest court, the Supreme Court, and a year later, the signing of the New York Convention. After these three events, I can say that arbitration became to be used as a dispute resolution mechanism widely in Brazil. Courts are very arbitration friendly, respect the competence principle, I think more than in the US, as Jennifer mentioned, the separability principles, and there are very limited grounds for annulment under the Brazilian Arbitration Act. Given this overview, I think those are the reasons why Brazil is the second country with most parties involved in ICC arbitration, only after the US. And also the fact, as Professor Gao already mentioned, that all awards that must be recognized, that are to be enforced in Brazil, will be recognized by the Superior Court of Justice. So just one court, and then enforced by federal courts in the different states in Brazil. So we have all decisions in one united court, which is very positive in my view, because we maintain a united front on how to deal with the issues that arise coming from abroad. Second slide, please. So here I put up a table that compares the grounds for awards not being denied, being denied recognition under the New York Convention and under the BAA, our Brazilian Arbitration Act. So they're basically the same. There is some distinction in wording, but the grounds are the same. It's interesting to see that when you analyze the case law, most decisions do not make reference to the New York Convention, but to the Brazilian Arbitration Act. Maybe because the act is from before, it's from 96, and we only ratified the convention in 2002. Maybe because justices are more accustomed to the Brazilian legislation than international treaties. But there's many scholars assess this circumstance, criticizing the Superior Court of Justice by saying that it should be more attuned to what the convention says and to the principles behind the convention. So not only the rules, but the reasoning why those are the rules that were adopted by all the countries that ratified this treaty. So now I collected some decisions that we are going to take a look at. Please, next slide. So the first case I found was the first France case, where there were parallel set-aside proceedings in Brazil. So this was an ICC arbitration seated in Miami. The party brought the award to enforce in Brazil, and the party seeking to bar the enforcement claimed that there was an annulment claim here in Brazil, and therefore the award could not be recognized. And the court came to the conclusion that the existence of an annulment claim in connection with that award before the domestic court, Brazil, was not an impediment to the recognition of that award. That was not an issue that would harm national sovereignty. It's interesting because the party brought the annulment claim in Brazil, even though the arbitration was seated in Miami. The judge of the first instance of jurisdiction granted the claim, annulled the award, but then the appellate court reversed the decision saying, look, under the New York Convention and under the Brazilian Arbitration Act, that lawsuit could only have been brought in Miami. So therefore, we cannot grant this request for annulment. So that's an interesting decision. And it's interesting that when the appellate court dismissed the annulment lawsuit, it made various references to the New York Convention and to the treaties, more than the Superior Court normally does. But the decision by the Superior Court was the correct decision when it chose to enforce the award coming from abroad. Next slide, please. So this is the EDF case, where the award had already been annulled at the seat. This is an ICC arbitration seated in Argentina, and the party had brought an annulment claim in Argentina, and it had been granted. So the party, ADF, sought to recognize the award in Brazil, and the court came to the conclusion that the foreign award, whether arbitral or not, has to have been res judicata in the country where it was produced to be recognized in Brazil. So if the award was declared null in Argentina because of a state court decision there that was confirmed, no longer subject to appeal, then the award is also null in Brazil and could not be enforced. This is a very good decisions to read, and when we all share the decisions that we are mentioning with the organizers, because this decision cites to the New York Convention, to other international treaties a lot, and the rationale behind it is very interesting to read. So it's another positive decision by our Superior Court of Justice. Next slide, please. This, I believe, is the most commented case, the recent case. It's the Abengoa case. There were two ICC arbitrations, both seated in New York, and the two awards were brought for enforcement in Brazil. In this case, enforcement was denied because of lack of impartiality of the arbitrator. So basically, the party seeking to bar recognition and enforcement of the award said that the chair of the arbitral tribunal was a member of a firm that had received payments from the group to which one of the parties belonged. Under Brazilian procedural law, if a judge is in that same situation, that judge would not be able to rule the case because it was representing a party related to the party. So when the issue was brought to the Superior Court of Justice, the decision that was the decision that the winning decision, I would say, was the one that denied recognition because it made reference to what our Code of Civil Procedure says, and saying an award issued by an arbitrator who maintains one of the relationships that are characterized impediment or suspicion under our Code of Civil Procedure will be an award that's offending national public policy, so it cannot be enforced in the country. This case is interesting because of several points. One is that there had been a lawsuit in New York in which a decision had been rendered saying that the arbitrator there was no issue with impartiality, that the award was perfectly valid. So when this case was first received by Superior Court of Justice, the reporting justice said, I believe that we are bound to what the US court has decided. Because when the US court decided that there was not an issue with impartiality under that law, then we should follow what that court decided. After he decided, the second justice to vote, Justice Noronha, disagreed with him, and that vote became the winning vote by saying that there's no reason for the Superior Court of Justice to be bound to that decision, and that it should assess the issue under the public policy of Brazil, and that the circumstance that is would offend national public policy. The decision the discussion is very interesting. There are commentary to both effects, agreeing and disagreeing with the decision. I personally think that the reason when the justice made reference to the Code of Civil Procedure, that was incorrect, because we're looking at public policy, something more international. We're looking at the New York Convention. We're not looking at our Code of Civil Procedure, which is something very domestic. But I also agree that given the facts of the case and concerning the duty to disclose that the arbitrator did not disclose this previous relationship because he didn't know, but that is a circumstance. I'm not completely against the final solution given to the case, which is non-enforcement. But it's a very interesting discussion. And we've seen, so Brazil, as I mentioned before, there are very limited grounds for annulment of domestic awards, and courts are very respectful of those limited grounds. But we have seen in the past years more awards annulled due to lack of impartiality of the arbitrators. So it's something to be very attuned to when asking for disclosures and investigating any potential ties that arbitrators might have to the parties. Next, please. Next slide, please. So here about two cases, the Inversiones and the Subway cases. Both are arbitration seated in the US, and both the parties seeking to bar recognition raised the argument that there was no summons of the parties that did not participate in the arbitration and was not properly served to participate in the arbitral proceedings. So in the first case, in the Inversiones case, there was a decision that's fairly common here in Brazil and completely correct, which is you don't need to have proof of the service as we know service under our Brazilian law, but you need to have evidence of undisputable knowledge regarding the arbitration proceeding. So if the party knew of the proceeding and did not chose to not participate, that's his problem. He was aware there's not an issue of due process. So that's the first case, the Inversiones one. In the Subway case, I brought it because it's an interesting discussion as well. The arbitration, the party participating in the arbitration, there's absolutely no issue with summons off the arbitral proceeding, but the party chose to validate that case in the US before bringing the award to recognition in Brazil. And then in that lawsuit, the party was not properly served. a rogatory letter should have been issued with the party being served in Brazil, and that was not done. So when the award came to be recognized by the Superior Court of Justice, Justice Fuchs denied, the reporter said, we cannot recognize this award because there was an international lawsuit where service was not properly carried out through the rogatory letter. I personally do not agree with this decision because there was nothing wrong with the arbitration per se. There was just something wrong with the proceeding that before state courts had followed it. But that proceeding was solely unnecessary. I mean, you don't need to validate an award before bringing it for recognition before the Superior Court of Justice. So I believe the more correct decision would have to been to validate this award and recognize under Brazilian territory. But it's an interesting decision nonetheless. And next slide, please. And I believe this is my last one. So this is the Deutsche Case, where the party raised the argument of absence of signature of the arbitration agreement. It's an arbitration seated in England, proceedings before the Superior Court of Justice, and the court came to the decision that the lack of evidence regarding the undisputable consent to arbitrate would offend our public policy, as it affronts the principle which requires the express acceptance of parties to enter into arbitration agreement. So this, it was based on the article of the BAA that requires a signature in writing. You need to have either the arbitration clause properly signed or a document, a letter or an exchange, an email, where the party expressly consents to arbitrate. Since this decision and in the past years, there have been multiple decisions of lower courts regarding domestic proceedings where a party, even though it was not a signature, an express signatory to the arbitration agreement, was brought into the arbitration. Under those theories that Jennifer mentioned, they're also applied by courts in Brazil, as saying that if there's tacit consent to arbitrate, that can be okay. And we have scholars that in the past wrote that you needed to have an arbitration agreement in writing that are also opening up their interpretation by accepting tacit consent in other ways. For example, when there's different contracts in one party, the parties enter into a contract where there's a collegated contract, extending the agreement to the parties to that collegated contract, etc. So I believe that this case that we've been seeing in the lower courts might come up in the Superior Court of Justice in the following years. Next slide, please. I think this was my last case. Yes. So I just wanted to sum it up by saying that case law in Brazil is, I believe, very pro-enforcement, very arbitration friendly, in line with the New York Convention, although the justices don't refer to the convention as much as they should, in my opinion. They are still in line with what the convention wanted because our act replicated the grounds for that a court might refuse to enforce and recognize an award. So thank you again for the attention.
Thank you very much, Maria, very much for this presentation. I think you raised a lot of very interesting cases, especially the Abengoa and the EDF case, both of which seem to take a very strong stand on part of the Supreme Tribunal of Justice on the question of the enforcement of awards. I will probably have the time to come back to the issue of conflicts of interest and the extent to which the enforcing court may do deference to the decisions of the rendering court of the award. I think that's a very interesting issue that may come up later on. And also, if we have time, the subway decision in regarding the extension of the arbitration agreement to either to non-signatories or to cases in which there's no evidence of the signature, that may also show a split in the views and in the Americas on that, on how strict to deal with that issue. But let's move on now to Colombia, where Eduardo Zuleta will be assisting us with these many developments in this area of the law. I would like to introduce Eduardo, who is a friend and a colleague and very well known to everybody in the area of international arbitration, just mentioning that he has been a vice president of the ICC court, member of the London Court of International Arbitration, chair of the IBA Arbitration Committee, and president of the Latin American Arbitration Association. He has been acting as an arbitrator both in investment and commercial, and not only in Latin America, but also in cases involving European, Asian, and parties from the Middle East too. He's a member of the sanction boards at the present time of the World Bank, as well as an adjunct professor at Georgetown Law School. Welcome, Eduardo, the floor is yours.
Alejandro, thank you very, very much. It's a pleasure. Thank you very much to New York City Bar Association for the invitation and to my colleagues for their excellent presentations. And I will start with a myth. This is a panel about dispelling myths in international arbitration. And the myth was, it is a Herculean task to obtain recognition and enforcement of an award in Colombia or elsewhere in Latin America. Well, that's a myth. First, we can all put all of Latin America in the same package. And as we've seen so far, the approach is diverse, but with a trend to uniformity in the approach to recognition and enforcement. In the particular case of Colombia, I would say that Colombia, and I've said this a number of times, Colombia can be defined as a country that exports arbitrators and import awards. This is because there is a line of jurisprudence that clearly favors the recognition of foreign awards, but efforts are still required to consider Colombia a reliable venue for arbitration. But that's a different topic and a different matter for a separate discussion. Colombia is a signatory to the New York Convention. I think is maybe the only country that has signed the New York Convention twice. It was declared, the law that approved the New York Convention was declared unconstitutional, and then a second law had to be issued. So we had a sort of a gap of 2 years where the New York Convention was mandatory for Colombia at the international level, but not on the internal level, which is something incredible, but that's the way it was. Now, in addition to the New York Convention, Colombia has an arbitration statute issued in 2012. It is based on the model law, and it reproduces in Article 112, almost verbatim, the exclusive grounds for refusal of recognition and enforcement provided for in the New York Convention. Under the statute, only 2 courts have jurisdiction for the recognition of awards: the Supreme Court, general rule, and the Council of State, but only with respect to awards issued in arbitration involving states or state entities. And that may create, as we will see later on, an issue in the jurisprudence of the recognition and enforcement. Another key issue is that the decision to recognize a foreign award is not subject to appeal. It's a once-instance decision. Once the court decides, that's it, except for the karma that we will talk about later on. So the famous or unfamous tutela or amparo, which is the karma of Latin American arbitration. Article 114 of the arbitration statutes contain a provision that is not included in the model law, but comes from a problem that was caused by the jurisprudence of the Supreme Court. Article 114 provides that the recognition of foreign awards shall be governed exclusively by the provisions of the arbitration statute and by the treaties or international conventions signed and ratified by Colombia. And it says, for the avoidance of doubt, the provisions of the Code of Civil Procedure on proceeding and grounds for refusal shall not apply and may only be applied for the enforcement of judicial decisions. Why is that? Because there was a famous case that most of you have heard about, the Merck case, in which the Supreme Court issued 2 decisions, January and March of 1999, where it considered that the recognition and enforcement were subject to the Code of Civil Procedure, and that the New York Convention was merely a substitute for the requirement of the Code of Civil Procedure to prove reciprocity. So it has a sort of a secondary level of, and the Code of Civil Procedure was the one prevailing. Further decisions of the Supreme Court, unfortunately, analyzed both the grounds for refusal on the New York Convention and the requirements of under the Code of Civil Procedure. And there was a sort of a joke in Colombia saying that in Colombia, the New York Convention was not a convention for the recognition and enforcement of foreign awards, but against the recognition and enforcement of foreign awards to the extent that it added requirements to those of the Civil Procedure Code. So instead of having 5 grounds for denying of recognition and enforcement and 2 ex officio grounds, we had like 17, and it became a nightmare. Now, 2 decisions of the Supreme Court were change the trend here. One is the HMT case, a decision of 24 June 2016, and the Tampico case in July 12, 2015, both decisions reaffirmed that the only grounds to refuse recognition and enforcement are the ones provided for in the arbitration statute and the New York Convention, which, as I said, are basically the same. The Tampico case is a very interesting case in the sense that the ground that was alleged to obtain or for refusing recognition and enforcement was a conflict of interest. And the argument was that the arbitrator in the particular case was subject to the disclosing requirements of the law of the place of enforcement. In other words, that the provisions on disclosure provided for under Colombian law were a matter of public policy, and therefore the court should refuse the recognition of the award. The court indicated first that the agreement of the parties provided for a sit in Chile. Number two, that the grounds for recognition, for disclosure were the ones provided for by the seat, and that the parties had agreed, moreover, that the rules were the IBA guidelines on conflict of interest, and that the provisions of the local statute on arbitration on disclosure were not mandatory and simply were a matter of internal public policy. As regards public policy, since the decision of Petro testing that was issued in July 27, 2011, the Supreme Court has had a very strict definition of what public policy is, and has stressed that it must be differentiated between international public policy and domestic public policy. And as regards international public policy, the court has said that the concept of public policy that may prevent a court from granting recognition and enforcement of a foreign award under the New York Convention is limited, and I quote, to the basic or fundamental principles of legal institutions that are necessary for the society, such as the prohibition to exercise rights abusively, good faith, the arbitral tribunal's impartiality, and due process. So the contravention of a mandatory provision of the law of the site in Colombia does not entail a violation of public policy, and therefore is not a ground for refusal of recognition and enforcement. This approach in differentiating amongst mandatory provision, national public policy, and international public policy has been followed by further decisions of the court, and it is the position of the Supreme Court now. Now, so the myth goes, it is a Herculean task to obtain recognition of an award in Colombia. No, it is not. The law and the jurisprudence today clearly favor the enforcement of foreign arbitral awards. Is it truly free of hurdles or free of bad decisions? No. Bad decisions, you find bad decisions everywhere. In Miami, in France, in New York, in all the key venues of arbitration, you find bad decisions. Courts are human beings, and they get wrong the law every once in a while. So this is a case, Colombia, as other jurisdictions in Latin America, where there's been an evolution that today makes the Colombia as a friendly jurisdiction for the recognition and enforcement of awards. What are the issues to be considered at the future? And what are the key issues to be considered in that evolution? First, the arbitral statute provides for only one round of pleadings for the recognition and enforcement. And there is an interesting precedent in the Tampico case where the applicant submitted the request for recognition and enforcement, the opposing party submitted the opposition, and together with the opposition, the opposing party submitted a number of documents as evidence. And the Supreme Court, despite the fact that that additional round was not provided for in the law, granted the applicant the opportunity to submit additional evidence just to preserve the right of due process. Second issue to be considered under the arbitration statute, as I mentioned, recognition and enforcement of awards against the status entities is subject to the jurisdiction of the Council of State. So far, the Council of State has only issued one decision on recognition of awards, the Isolux decision of 17 April 2020. The decision recognized an award issued in Texas, applying the New York Convention. The decision is a pretty standard decision, but it left doubts as to the position of the Council of State as to what is international public policy when the state or state entity does not act iure gestionis with iure imperi. And there are doubts because of that decision as to what is the criteria of international public policy that the Council of State would apply in case, for example, of recognition of non-ICSID convention investment foreign awards, Uncentral awards, for example, in investment cases. And last but not least, that I already mentioned, the karma as to whether constitutional actions, tutela, amparo, and the like, may affect the decisions to recognize an award. So far, none has been filed at the stage of recognition, and as far as I know, only one has been filed at the stage of enforcement. And even though it was rejected, again in the Tampico case, it caused substantial delays in the proceedings, to the extent that I think that when I retire, I would like to write a novel on the Tampico case. It's been a case that is going on for like 9 years now, since the issuance of the award, with all sorts of courts intervening in the issue of recognition and enforcement, but mostly because of this issue of tutela and amparo and constitutional actions. In a nutshell, I think that, as I said in the beginning, Colombia is a friendly jurisdiction for the recognition and enforcement of awards. The timing of the courts is a reasonable timing. The court is applying the New York Convention by the book and is applying the grounds of the arbitration statute by the book. And what is to be seen is what would be the reaction of the Council of State. And so far, and with this I will conclude, the Council of State in connection with annulment of awards, which is, again, there are two jurisdictions for the annulment of awards issued in arbitrations, in international arbitrations in Colombia, the Supreme Court and the Council of State. The Council of State in connection with annulment of awards has taken a totally different position than the position taken by the Supreme Court. So it is likely that, unfortunately, the Council of State may take a totally different approach in connection with the recognition and enforcement of awards when they affect the state, particularly, or state entities under the theory of attribution. That's basically it. Alejandro, thank you very much.
Thank you, Eduardo, very much, especially for the issues that you brought up. The last one, especially regarding the potential position of the Council of State on issues of international and public policy. I really very much look forward to it because that's an issue of interest in Latin America in general. State agencies, sometimes they have been, again, regarded with a different kind of standards as opposed to private entities. And I think that this is an interesting issue to see what is going to happen in the future. On the acción de tutela also, we are looking forward to see more definitions of this, but we have a lot to hear from Elsa Ortega on probably on the amparo proceedings and the type of challenges that come up in Latin America on constitutional remedies and recognition and enforcement of awards. I would like to introduce Elsa Ortega, not only as a Mexican lawyer and arbitrator with much experience, but also as a co-author of a book by the name of Ley Mexicana de Arbitraje en Materia Comercial, and also as a member of the Advisory Committee on Private Commercial Disputes of NAFTA, currently the USMCA, appointed by the Mexican government in that position. She is a founding partner of Ortega and Gomez Ruano, a law firm based in Mexico City, where she practices mostly in the area of international commercial arbitration and commercial transactions. Elsa, welcome. Unfortunately, we have, again, the limited 10 minutes as usual, but we are very much looking forward to hearing you.
Thank you. Thank you very much, Alejandro. I would like to start by thanking the New York City Bar for this invitation. I'm very honored to be part of this panel. And I prepared a couple of slides just to help the audience follow the ideas that I want to share with you. I'll try to be very, very succinct in my explanation because I know we have very little time left. So if we can go please to the next slide, I will start by speaking about, some general considerations of the case of Mexico with respect to the enforcement of arbitral awards, just to understand the specific topics that I will touch upon later on. So first, Mexico is an Uncentral model law jurisdiction. In 1993, it adopted the Uncentral model law and it incorporated it into its Commerce Code. So Title 4, Book 5 of the Mexican Commerce Code is our Mexican arbitration law. It is a federal law and therefore applicable in the whole of the Mexican Republic. This law has been amended only once in 2011, and at the time they incorporated a new chapter, Chapter 10, with specific rules on the role of the courts with respect to matters related to arbitration. So two of these matters are, of course, the annulment of arbitral awards and the enforcement of arbitral awards. And for that purpose, the Mexican legislator created a new proceeding called the Special Procedure on Commercial Transactions and Arbitration. Also is relevant to mention that Mexico is a signatory of the New York Convention and also of the Panama Convention. And with all of this framework, in Mexico, there is a presumption on the validity of arbitral awards and also of their binding force. There is no need for a special procedure for homologation of arbitral awards, and the reasons for opposing the enforcement of arbitral awards are limited and only for very serious cases. This special procedure on commercial transactions on arbitration at the time of enforcement of an arbitral award is not an appeal. The judge may not study the merits of the dispute again, since they have already been resolved in the arbitration award. And also I should mention that an action for enforcement of arbitral awards may be initiated before a federal court, but also before the state courts in Mexico. Now, if we can please go to the next slide. With this introduction, I will now touch upon three specific topics that are relevant on the enforcement of foreign arbitral awards in Mexico. These are the results of recent decisions of different courts in Mexico. The first of these topics is the question of the amparo. In Mexico, we have a special proceeding against actions by the government or authorities when an individual's rights, human rights or constitutional protections have been violated. And this is the amparo proceeding. So the first question that comes to mind is whether there could be an amparo proceeding against an arbitration, against an arbitral award. And here there is really no debate, because the Mexican courts have consistently confirmed that an arbitrator is not an authority for the question of the amparo. So there cannot be an amparo proceeding against an arbitral award per se. However, when there is a decision by a judge in one of these enforcement proceedings or annulment proceedings of an award, well, the judge is an authority for purpose of the amparo in Mexico. So there could be an amparo proceeding against this final decision by the judge in these proceedings. So the question here and the debate has been in Mexico, which kind of amparo is applicable in this case? And in Mexico, we have two different kinds of amparo. We have the direct amparo, which is of one instance only. And this is against final judicial decisions in a trial or rulings that terminate a trial. So it's mostly against acts of a judge. And this is the direct amparo. And then we also have the indirect amparo, which is of two instances, and therefore it takes longer to adopt, which is against acts that are not final decisions in a trial or acts that are not a ruling terminating a trial. And this is, as I was saying, of two instances. So for a long period of time, the interpretation in Mexico was that against the final decision of a judge in an action of enforcement of an arbitral award, the applicable amparo was the indirect amparo, and therefore of two different instances. First before a district judge, and then before another court in an act of revision of the original judge's decision. And then in 2011, as I was saying, the Mexican arbitration law was amended, and this Chapter 10 on the role of the courts with respect to arbitration was included into the Mexican arbitration law. And the Mexican arbitration practitioners were very careful to promote that the text of the law now clarifies that any action of enforcement of an arbitration award or annulment of an arbitration award is conducted under a special procedure of commercial transactions and arbitration. So to be understood as a different trial, and therefore the judge's final decision in one of these proceedings must be understood as a final judicial decision decision that puts an end to a trial. And therefore, the amparo directo, or direct amparo, which is of one instance, is the one that is applicable now against these final decisions by the judge. And this, after this clarification in the law, was the prevailing interpretation for several years. However, what is interesting is that in December of 2019, a new case came before the Supreme Court of Justice in Mexico. And here the court had to analyze two opposing judicial precedents. And here the court decided that the amparo indirecto of two instances is the one that it's applicable, notwithstanding that the enforcement of the arbitral award is conducted in a special procedure or trial. And the reason for that was that the Supreme Court considered that in this procedure for recognition and enforcement, the judge does not solve the merits of the dispute between the parties, and therefore this cannot be considered a real trial, and therefore a real decision terminating a trial. So in other words, for the Supreme Court, there are no real claims in these kinds of enforcement actions, and therefore the amparo indirecto is the one that is applicable in this case. This decision by the Supreme Court is binding on the rest of the Mexican courts, and the consequence of this is that in the future, against the final decision by a judge in an action of enforcement, the courts will interpret that the indirect amparo will be applicable, and therefore it will take longer to go through the two instances of the amparo proceeding. The second question that I would like to address very quickly is the requirement of authentication of arbitral awards. In Mexico, in Article 1461, second paragraph of the Commerce Code, that is based on Article 35 of the Model Law, there is a requirement that for a party that is seeking the enforcement of an arbitral award, this party should produce before the court the original arbitration award duly authenticated. And this was based, as I was saying, on the original text of the Model Law, which used to include this requirement. However, as we all know, in 2006, when the Model Law was amended, the Model Law abandoned this requirement. And the fact is that in Mexico, we haven't made this change yet. So we still have this requirement of duly authenticated arbitration awards for the enforcement. In Mexico, the authentication of private documents is mostly done before a notary public who ratifies the signature of the author of that private document. So a practice was established in Mexico, and later on it was confirmed before the 14th Collegiate Circuit Court, who issued a judicial precedent in this sense, where the party requesting the enforcement of an arbitration award had to prove that the arbitral award was indeed issued by the respective arbitrator or arbitrators. And this was done by requesting the arbitrators to appear before a notary public to ratify their signatures in the award. In October of 2020, in this decision, the review of Direct Amparo 7856/2019, the Supreme Court of Justice had to analyze this question and resolve that this requirement is unconstitutional. The reasoning of the Supreme Court was that awards in Mexico are inherently valid and have a binding force. And therefore, the requirement for duly authentication of the arbitration award must be understood not as a precondition for confirming the formal or material validity of the arbitral award. Rather, the authentication requirement is only a mechanism to give the award additional certainty as to the signatures of the arbitrators, and to reduce the probability that the defendant in an enforcement action would argue that the arbitral award is false, and therefore delaying or complicating the enforcement action. Hence, the lack of authentication of the arbitral award does not mean the award is not authentic or that it is false. And therefore, the Supreme Court concluded the requirement for authentication of the arbitral award is disproportionate and is unnecessary, and therefore is unconstitutional. And then finally, very quickly, this is the question of the statute of limitations for an action of enforcement of an arbitral award. This is an isolated judicial precedent and therefore not binding for other Mexican courts, but it can be invoked by arbitration practitioners in Mexico. And in this case, the case was an arbitral award rendered in New York that was being enforced in Mexico. The defendant argued that the statute of limitations had expired, and the court had to decide whether a statute of limitations of 3 years that is provided in Article 1079, Section 4 of the Commerce Code for judicial decisions in summary judgments, oral trials, or other special proceedings in commercial laws is applicable, or whether the general rule of 10 years in Article 1047 of the Commerce Code was applicable. And the reasoning of the court said here, there is no specific rule for actions of enforcement of arbitral awards in Mexico. Certainly, an award is not a judicial decision, or an arbitration proceeding is not a special trial according to Article 1079, so that is not applicable either. And therefore, the general rule in Article 1047 of the Commerce Code of 10 years as a statute of limitations is applicable. And I think I'll stop here because I know we have very little time. Thank you very much for your attention.
Thank you, Elsa, very much for these precisions. I think that one is encouraged by these two last points on the unconstitutionality of the authenticity requirement, which I think is very clear, as well as the 10-year statute of limitations that really adds clarity. I'm a little bit disappointed with the indirect amparo requirement because, of course, it will take longer. That's a concern that Eduardo already raised regarding the acción de tutela, and that continues to be the karma, as he points out, of our in some jurisdictions. We see that exactly that our time is out. It's unfortunate because one of the speakers wanted to know on each jurisdiction, how long does it take actually to recognize and enforce an arbitral award? But I want to get to the organizers, first of all, by letting the audience, give the audience please to take note of the code for the CLE credit, which is capital ARB 366. I repeat, ARB 366, and please file the forms that are in the New York Arbitration Week, as the organizers already have established. Our time is up, and I think that I may go back to Leah now, if you would like to please give the last words. Leah?
I was actually told Professor Garro that she's not going to log back on because she thought we'd be out of time, so.
Okay, so.
I actually am.
Go ahead. Okay, well, we cannot hear you, Leah. No? Should
No,
we
she's
be
muted.
Yes, she's muted. And
Thank
then
you.
now,
Here.
go ahead.
Thank you very much to all of you, and it was really a pleasure and a great panel. So and thank you for Professor Garro. Thank you for that wonderful job moderating it, and all of you for coming. And hopefully we'll see you at some of the other programs on New York Arbitration Week this week. Take care, everybody.
Thank you. Good evening. Good.
Thank you very much.
Thank you very much to all. Stay safe. Take care.
Thank you very much.
Thank you.